Buddy. Shake your heads if you could hear me okay. Good, okay. So for me, life took a fork in the road 42 years ago when my second child, Mitchell, was born. Mitchell's has autism. He functions at a fairly low level for autism, which is a wide spectrum, but he's on the lower end of the spectrum. But doing really quite well right now. He's living in a small group home run by an agency named Clearbrook, a board I've been on 34 years now, and doing quite well. He sleeps over once a week at our house and comes to the office and does shredding for us and things like that. But doing pretty well. But with Mitchell's birth, my practice took a fork in the road. From doing general estate planning, it became real quickly concentrated in the area of special needs planning for my fellow families of children with special needs. And basically about 2001, 22 years ago, it became limited to just serving families of children with special needs, children and adults. Here's a picture of Mitch. On the right-hand side, you see him as best man at his brother's wedding. Again, doing quite well right now. And with that, let's start. One of the first questions that families always ask when they come in is, okay, if I have one of my children with special needs, how much money do I need to leave for them? And I tell families, when you plan for college education, you say, all right, for X number of years out, what's tuition going to be, inflation, return on investments, and you get a number. If you have a heart attack and die because you can never save that amount. But bottom line is you got to. But for us, our child with special needs is what is their own earning potential? Are they going to be able to live independently with assistance? Are they going to live residentially under an agency? What government benefits are they eligible for now? What government benefits will even exist 5 years, 10 years down the road? And of those, what will they be eligible for? There's so many variables in there. Well, we can give you some guidance in that. The real question is, in what manner do we leave any reserve fund that we're going to leave so it doesn't interfere or jeopardize or reduce the government benefits? So think of it that you're building a pyramid. The base of the pyramid is government benefits. We don't want to do anything that's going to jeopardize or interfere with government benefits. It's the base, the foundation. We want to build upon that because we want to secure government benefits, Social Security that we'll talk about, cash program, but Medicaid, more importantly, which pays programs in addition to medical supports. And they have asset tests, resource tests. If we want to leave a reserve fund, we can't build up money in their own name. For many of us, our child with special needs can't take care of their own funds. But more importantly, it's going to interfere with their government benefits. So this concept of special needs trusts has been around since the early 80s in Illinois, by statute in Illinois going back to 1991. That if we dot our I's and cross our T's, we could have a reserve fund over and above government benefits. There will be a reserve, will not interfere at all with the government benefits. And they still could work with the limitations and still make some money and not lose the government benefits. So basically, why do we need special needs trust in this thing called an ABLE account that I'm going to talk about? Because government benefits have resource tests. Supplemental security income has a $2,000 asset test, resource test. And that's been the same for, God knows, since the early 70s. We get inflation, it hasn't changed. Periodically over the years, Congress talks about increasing it, but never gets ahead. So it's $2,000 is the cap. Down the road, if somebody has a work record or they're on Social Security and then their parent passes away or goes on disability or retires, and they go on the parent's work record, that program does not have a resource test. But it's an important program because 24 months after they're on some Social Security disability insurance, SSDI, they get Medicare. Medicare is good because it pays 100% of hospitals, 80% of doctors, and most doctors take it, unlike Medicaid, where a lot of doctors don't take it. There's different ways you get Medicaid in Illinois. First of all, throughout the country, there's 41 states and DC. When you apply for SSI, you automatically get AABD Medicaid, traditional Medicaid. Same application, same rules, no problem. There's 9 states that are called 209B states where there's separate application, and they have their own rules for one of those states. The nice thing is, well, we had the same $2,000 asset test for decades and decades. Governor Pritzker, who's probably the governor who's been the most favorable to our community in generations, a few weeks ago increased a $2,000 test for Medicaid up to $17,500. Somebody can still have traditional Medicaid. There's another program called Medicaid Buy-in, HBWD, Health Benefits for Workers with Disabilities. That somebody's working, they're taking Social Security out of their check, and they could paying a small premium, get Medicaid. It'll let them go up to $25,000 in assets, and more importantly, they could have IRAs, 401ks, retirement plans. So there's 3 different doors in Illinois to get Medicaid. The ACA, Affordable Care Act Medicaid, is also available, but if they're on Medicare or they're getting SSI or SSDI, AABD is the type of Medicaid that they're going to be on. So, having said that, people say, well, I still have my child and I have insurance, and they told me they can stay on my health insurance till 26, be it a private policy or an employer policy. Actually, as bad as Illinois is in a lot of areas, they have a very good statute that goes back to 1969. It says if a child is on SSI or SSDI, they can't be kicked off the parents' health insurance, be it private or employer plan. Even if the parents can't claim them as a dependent in their tax return, even if the parents, the child's not living with them. Basically, the statute says that if they're incapable of self-sustaining employment, same language as Social Security uses to get SSI or SSDI, and dependent on his or her parents or other care providers, living residentially, Lamb's Farm, Misericordia Group Home, they can stay on the parents' health insurance, which we want until they can get to Medicare, because we don't want them to rely totally on Medicaid. Most hospitals take it, pharmacies, a lot of doctors don't. So we want to keep up private insurance as long as we can. One of the things that Katie sent out was a request form, and I'll periodically point to it. Number 4 on the request form is more information on the 2 statutes that allow somebody with special needs to stay on a family health insurance or employer group health insurance past 26, number 4. So we want to get services from the state of Illinois. We go to the Department of Human Services. But which door? DDD, Division of Developmental Disabilities. Division number 2, DMH, Division of Mental Health. DRS, Division of Rehabilitative Services. They each have their own systems for getting services. Door number 1, Division of Developmental Disabilities for Intellectual and Developmental Disabilities, uses the PUNS, P-U-N-S, database to be in line for services. Division of Rehab Services uses a DAN score, determination of need. Some of our individuals that have minor cognitive disability can get services from DRS. They have their own Medicaid waiver. So I want to point it out. It's beyond the scope of our presentation tonight. But I just wanted to point it out that if somebody doesn't qualify as developmentally disabled because their IQ is too high, their functional limitations is not great enough, they still can get services from the state and a Medicaid waiver through the Division of Rehab Services using the DAN score, not PUNS, but DAN, determination of need. So where are we? We know that if we have a loved one with special needs that may be on government benefits or really can't take care of their own money, then we don't want to leave money directly to them. So if you don't have a will, I'm not leaving any money to them. Well, that's not exactly correct, because every state has a law that says what happens if you pass away and there's money in your name, no named beneficiary, no surviving joint tenant, purely your name. In Illinois, if you're married, half goes to spouse, but the other half goes to your kids. If one was on benefits, you just interfere with their government benefits. So some families over the years would say, oh, just disinherit them and leave it to my favorite sister, or leave it to their brother or sister. Moral obligation to really use it for them. They might have that moral obligation, but they may have IRS or credit problems, or when they pass away, or they leave their money to, and not have that same moral obligation. So it's not necessary. Well, until 1982 in Illinois, people used what they call a traditional trust. If we pass prematurely, we leave money to our kids, somebody will watch the money till they're an older age. And for the child with special needs, will be kept in trust for their lifetime. But in 1981, lower court case, the state of Illinois went to court and broke those type of trusts. Said if it says you can use it for basic support, great, use it. When you run out of money, then come back to us. That was the birth of special needs trusts. Note the S plural. There's two kinds of special needs trusts. There's a third-party trust, which is the original kind of trust, birthed by an appellate court decision in Illinois in 1982, statute September 6, 1991 in Illinois, that gifts and inheritances, not their money, not the child's money, gifts and inheritances from other people, left in a bucket, third-party trust. It's over and above government benefits, will not interfere or jeopardize the government benefits, and it'll be a true reserve fund. But then, in 1993, the federal government came up with another type of trust. Illinois always right in there. It was 1996 before they accepted it, called a self-settled, also known as an OBRA trust or first party or a payback trust. This is for their money. Maybe there was a litigation settlement, they got an award. Maybe grandma left them money, not doing it to a third-party special needs trust, but just to them directly. Or all of a sudden they're working and they're not spending their Social Security fast enough in their earnings, and they're having a problem, too much assets in their name. The self-settled trust works like a third-party trust, except when they pass away, first in line to get reimbursed is the states that provided Medicaid services, in our case, Illinois. So the state can't go after the third-party trust, but they can go after the first-party trust, reimbursement. So what do they have in common, both trusts? They're both reserve funds over and above the government benefits. There's no limit to how much money is in there. And they're not using smoke and mirrors, they're federally and state approved. So again, the third-party trust, appellate court case 1982, statute 1991, Illinois. The statutes were revised when 2020 is a new number, but still same statute. Gifts and inheritances, not their own money. We'll talk about that. So the third-party trust, the picture always helps. Inheritances coming in on the left there, gifts, beneficiary and IRAs, 401ks from parents, but not their own money. Not child support if there's a divorce, more about that in a minute. Not their own money. This is third-party money, other people's money, leaving it for them in the bucket, special needs trust. And when they pass away, state has no claim against the third-party trust. It's the parents decide where it goes. Does it go to the other children? Does it go to agencies? Does it go to other family members, charity, whatever? Point being, the state of Illinois has no claim against a third-party trust. So mom and dad in their will or their living trust make a little fatter and say, okay, here's a special needs trust inside here. The language here is for my other kids, but for this child, there's a special needs trust. And the answer is no. We don't want it inside parents' will or living trust. We want a freestanding document. It's not inside their document. Why? We need it to exist now, not just when mom and dad pass away. Why? A lot of different reasons. Number one, what I call piggybacking. There's aunts and uncles that don't have their own children or have a lot of money, want to leave money. Grandparents, I'm not leaving it to him, I'm leaving it to you. But mom, dad, if I pass away before you, your document says it goes to my kids, that means you're going to mess up their benefits. We want a extended family to be able to piggyback onto the special needs trust, friends, relatives. There's a 1985 Illinois Supreme Court case that says if we do this, you pass away and laws change, we'll be grandfathered if we set it up now. It's free nursing home insurance. What are you talking about? Grandma's going to a nursing home. She has enough money to last 6 months, 8 months, whatever. It's a memory care unit, it's $12,000 a month. Well, she'll give her money away to the other family members and they'll keep their fingers crossed, they'll use it for her. No. Federal law says there's a 5-year look-back period. You can't give your money away and say, state, pay for me, I have no money. 5-year look-back period. Federal law exception to the rule. Moving it into a special needs trust, with the special needs trust has certain language in it, then the next day, it's called a permitted transfer. The next day, grandma's eligible for Medicaid. May not be grandma, maybe mom or dad, maybe sister, brother. But it can be used for somebody else to qualify for Medicaid, avoiding the 5-year look-back rule. And then grandma's giving gifts to everybody. Well, it's something you're spending the next week, who cares? If they're larger gifts, we want a place that it can go without interfering with the government benefits. At this point, people say, stop, I don't get it. I know what a will is. Who gets my money when I die? You keep using this term, a trust, and I can't get my arms around just what is a trust. Think of it as just another way of holding title or ownership to the assets. Instead of little Johnny's name, it's little Johnny's Special Needs Trust. What's the document for? The book of papers, the trust agreement. Think of it as the instruction manual or the rules of the road. That if there's an account, there's an investment in the name of the trust, this tells us how we can spend the money, when we can spend the money, who's in charge when we check out, who gets whatever's left when little Johnny checks out. Who could put money into this trust? Parents, siblings, grandparents, anybody except not little Johnny. We're talking about a third-party special needs trust. And mom and dad can be the trustees now, but like with my special needs trust, it's empty. It's only going to get funded when my wife and I pass away. But they're the trustees now, and they could pick who are going to be the trustees afterwards. If they don't have any other trusted family members or people they want to use, there's a couple of chapters of the Arc of Illinois that serve as trustees of special needs trust, and have been doing so going back to the early 80s. It's a third-party special needs trust. But okay, mom and dad set up special needs trust. But what about other people? As I said, grandparents, aunts, uncles. Sometimes they say, I'm not leaving anything to them. Aunts and uncles, I'm leaving it to my own family, but there's nobody left. The boilerplate language says it goes to my close living relatives. They could be little Johnny. So what we tell people is we need to educate other people. What we do is to give them an instruction letter. Family and friends of little Johnny. If you have a document, you're going to leave anything, little Johnny. Here's how it should be done. We have a will already? Fine. Here's a fill in the blank form to add on a paragraph that if anything goes to little Johnny, it will now go to the special needs trust that his parents established. You have a living trust by probate. Okay, fine. Here's a fill in the blank form to add on a paragraph to the living trust so that if anything goes to little Johnny, even unintended, his name isn't in there, but he's in by category, descendant, heir at law. If something trickles down to him, by adding this paragraph on there, we're making sure it goes to the special needs trust. Okay, so we set up the special needs trust. We refer to it in mom and dad's wills and trusts, and we educate the extended family. We're not done. Why? We need to change beneficiaries. What do I mean by that? Well, life insurance, IRAs, 401ks, profit sharing, anywhere that you name a beneficiary or you put a POD, pay on death, that's contractual and that bypasses, it never makes it to the special needs trust. We have to make sure that the beneficiaries listed always refer to the special needs trust. So the attorney, again, should be saying, now here's your special needs trust. Here is the instruction letters on how to list beneficiaries. This should be part of what the attorney is doing for you. So make sure that all beneficiaries are correctly listed. So everything points to the special needs trust. That's a third-party special needs trust. But what if it's too late? They're on benefits now, but all of a sudden somebody passed away and didn't listen to you, and here comes $50,000 payable to little Johnny. Whoops, you got 10 days to tell Medicaid and Social Security that they got money now, and you got to reimburse them, and okay, they're going to lose it until it's spent, lose their benefits until it's spent down, and all kinds of things. Well, if it's a 529 account, don't worry about it, it doesn't count. But what else we do? Talk about a lot of these things individually in a moment, but if there's too much money in their name, they qualify with special needs, qualify, but now they have resources, assets beyond what SSI would allow, beyond what Medicaid would allow. Well, depends on how much it is. Maybe we spend it. Okay, but no, there's too much money. We're not just going to spend it documenting what's spent for their benefit. So the next option is an ABLE account, ABLE. Relatively new, federal law 2014, Illinois 2017. And it says, okay, you can put up to $17,000 a year of their money into it. Not per giver or donor, but from all sources, 17,000. Oh, but they changed the law in 2018. And they said, if the individual is working, then they can put their earned income in there on top of the 17,000, up to a limit of 13,590. But if they're covered by a retirement plan, an employer plan, then they can't do that. It's capped at 17,000. So we can put their money in there, okay. You can't get around that 17,000 by having more than one account. It's one account per beneficiary. And depends on the beneficiary. They're the owner. If there's no guardian appointed, and they're over 18, they're the owner. So there's no trustee protecting the money. It could be at risk. If they're on SSI, yeah, able account can't go over 100,000 or their SSI is at risk. Federal law says it has to be disability related expenses, but the IRS is watered it down to the point now that it basically is if it's spent for their benefit, there's not a problem. However, there's a payback when the child passes away to Medicaid, just like the first party payback trust. Now, some states like Illinois have a statute that says, no, there's no payback for able accounts in our state. However, it's Illinois law, like in other states, says except as federal law requires otherwise. And federal law does require otherwise. CMS, the Federal Medicare and Medicaid Agency, says for Medicaid waivers, home-based support service, residential waivers, DRS waivers, it says for those waivers, they have to take from payback. And any medical expenses post-55, they have to take Medicaid, they have to take payback. So we don't want to put third-party money in here because we use a third-party trust. There's no payback. So this is really for first-party money. They say it's tax-free as an incentive to put money in an able account, but keep in mind, who's the tax to? The individual with special needs, who has their own standard deduction, and it's at a minimal tax bracket, so it's really not much of savings. So when do we use able accounts? They're getting Social Security, they're working, we can't spend the money fast enough, they're having a problem with the resource asset cap, be it Medicaid or SSI. Remember, SSI cap is 2,000, Medicaid just went up in May to 17.5. If they're on Medicaid through HBWD, health benefits for workers with disability, 25,000 plus qualified plan benefits. So the able accounts is there as a place to split their first party money. Short-term savings for saving up to buy a car or something, bedroom set. If we have an individual that really we want them to have direct access to some money. They can't have direct access to the special needs trust, but they can have an able account if there's no guardian. So we could put in maybe $100 a week or every couple of weeks. They could have direct access to. So it's another use of an able account. Grandma left 25,000 to each of the grandkids. Well, we'll have to go to first party trust, but if it's under 17,000, we could use an able account. Child support. Child support cannot go to a third party trust, cannot go to the custodial parent, but in the divorce, it's got to go to a first party trust unless it's under 17,000 in a calendar year. And then we could use a able account. 529 accounts does not count as a person's assets, but we can convert it to an able account if we want to, again, up to the 17,000 a year. So earned income still counts. An able account covers resource assets, but if they're earning too much money to be qualified as disabled under Social Security's definition, the able account won't help that. It helps for an asset or resource test. You want more information on able accounts, number 11 on the request form. The first party special needs trust, again, as I said before, 93 federal law, 96 Illinois law. And a lot of different names for it, as I said before. Picture coming from litigation or bottom left from inheritances and gifts not corrupted of a third party trust, money that's in their name, or from a divorce, child support. And here it is, when they pass away, before even a funeral bill, the state is reimbursed for any Medicaid that was paid during their lifetime. But during their lifetime, it protects their government benefits. So that's why we always say, if you have a first party trust and a third party trust, always spend this first, because the state can't go after the third party trust. You say, how do you get child support for a child that's over 18, over 21, over 22? How do you get it? Illinois has a law that says that if there's a divorce, there's child support being court ordered, that the judge has the ability to require child support for the rest of the child's lifetime. And specifically in the statute, it refers to a first party payback trust as the appropriate place to put it. If it's paid to the custodial parent, dollar for dollar reduction of SSI causes things to spend down for Medicaid. So we got to use the first party trust or an able account. So you want information on child support if there's a divorce, it's number 3 on your request form. So we don't leave money directly to an individual in government benefits. We leave it all to a third party special needs trust. If there's no alternative, and then and only then do we go to a first party special needs trust or an able account. So they're working, they have Social Security coming in, they have a third party trust from gifts and inheritances, and they have an over trust, a payback trust, or an able account. When they're buying a pair of shoes, they're buying a new bedroom set, whatever. We always use their work earnings first, because again, catch-22, too much, so we lose benefits. Next, we use the Social Security. Again, we can't save it in their name. Over the resource test, we'll have a problem. Then we use the first party trust or enable account because there's a payback when they pass away. So this next bucket we use. The last bucket we touch is a third party trust because when the child passes away, it goes where the parents want it to go. Other kids, charity, whatever, but not the state. So some people say, well, I already have a trust. Was it approved by Social Security and the state Medicaid agency, HFS? Both federal and state laws say that if you have acquire resources or special needs trust funded, after you are on benefits, you have 10 days to advise Social Security and Medicaid of that. How do they find that out? Periodic Social Security and HFS redeterminations for disability, redeterminations for resources. So what do we see as common mistakes when we teach the continuing education course for attorneys on this? Special needs trust has to be 100% discretionary. No pun intended, we're trusting our trustee. You don't have to spend a nickel, trustees. If you spend anything, it's got to be spent for the primary benefit of the beneficiary. We don't want money going directly to the beneficiary, because if it goes directly to the beneficiary, dollar for dollar reduction of SSI causes the spend down for Medicaid. But the trust could allow kicking out money from the trust, the third party trust, to the able account where the child can have direct access. We don't want over restrictive special needs trusts that say you shall not use this for food or shelter. Why? Well, if the trust spends money for food or shelter, it's a 1/3 reduction of SSI. But for most of the years, the child's not going to be on SSI, they'll be on SSDI, which doesn't have any reduction. Further, we don't want over restrictive trust that says you have to exhaust all government benefits, because let's say that it's going to a doctor, takes private insurance, maybe Medicare, but not Medicaid, the 20% copay. Oh, the trust will pay it. No, not if the trust is over restrictive and says you have to exhaust all government benefits. You could have gone to a Medicaid doctor. So again, we want to trust our trustee, no pun intended. Well, what if laws change or different interpretations that Social Security has done periodically? Well, it should be grandfathered. If it's not grandfathered, you always want to give a provision that the trustee can modify the trust to the extent necessary. Laws change in the future. 2001 and 2011, Social Security clarified the rules in special needs trusts. It's always been this way. We're just clarifying it. And they applied it retroactively. So starting 2001, they put retro clauses in the trust. If we make a change, our change is retroactive. All right, for trustees, for our typical children, until we have a trustee until they're 25, 30 or something. For this child, we have a trustee for the next 80, 90 years. Well, the child may outlive the people we put in there. So we always going to give the power to our trusted individuals to add on the next generation. So they can add on more people. We want to trust to allow contributions, a third party trust, not a first party trust, or gifts. So the state pays, Illinois is one of the lowest paying states for residential services. Even if you get into the residential, what they pay per capita is a fraction of most other states. So if you want that, not 8-person group home that the law allows, but you want that 3-person group home, making contributions to the agency, well, if I'm gone, I want my trust to be able to make contributions to organizations providing services to my son. It's in the trust. Gifts. We give gift cards periodically to staff people who are grossly underpaid. So again, when we're gone, I want the trust to be able to be used by his brother to continue doing those things. Some of us, you say, well, you know what? I'm not sure that we really need this. I'm hoping that down the road, they're going to be able to be self-sufficient, not on government benefits. You could put in a termination clause that the trust can be terminated by the trustees. They're not on benefits and trustees are comfortable, they can handle their own funds. Okay, but when they pass away, the child with special needs passes away, where does it go? It goes to the siblings or nieces, nephews, or whatever. Okay, what if one of them has special needs? Maybe it's a to-be-born grandchild that has special needs. Language that says if anything goes to a contingent beneficiary of special needs, it goes to a special needs trust for them not to mess up their benefits, the next generation. Special language I alluded to before about for a nursing home, special language has to be in there so that grandma, aunt, uncle, mom, dad can use it as a receptacle to qualify themselves for Medicaid. Okay, mom is a teacher, dad's a university professor, there's military pensions. Public pensions have a provision, most of them have a provision that the retirement annuity can be paid for life to a special needs trust. But some have specific language that has to be in the document in order for it to be acceptable. So if there's a public pension, we've got to make sure that there's the required language is in there. Okay, so now we have 3 or 4 people listed as trustee, successor trustee, successor trustee. We always have to list a professional at the end. Why? Illinois law says if we don't do that, beneficiary can control who the trustee is, and the trustee can be the beneficiary, and it will no longer be a valid special needs trust. So we always have a professional trustee. They're not all created equal. Some of the larger trust companies are very good at special needs trusts, many are not. But there's also a couple of chapters of the Arc of Illinois that not-for-profit social service agencies that do a great job. But the choice in 2023, it's a great choice, may not be a great choice 20 years from now. So we trust our individual trustees, give them the ability to change the professional trustee, contingent professional trustee. Okay, so no laws changed. We passed away, and now my child is moving to see by his brother in California or whatever. Getting Medicaid from a different state. Social Security, change of address, Medicaid to start over again. What are the requirements in that state? Maybe different in Illinois. Provision allows the trust to be modified, not because of a change in law, but a change in location, a different state. Maybe it's mom and dad are retiring, taking their child to special needs with them to Florida, Arizona, or whatever. The ability to modify the trust if necessary. Other documents also have to be modified, such as your wills. The wills say, when we pass away, you nominate a guardian for my minor children. For us, it's not good enough. If our child is over 18, we want the ability to nominate guardians. Even if you're not a legal guardian now, because people are bending the rules for you or whatever, it's working. If a guardian is necessary, you want to be of record as to who should be guardian. Illinois law is, we'll talk about in a moment, allows parents to nominate who should be guardian if necessary in the future. It's done in the wills. Living trusts have a provision, living trust with white probate. If I'm alive but not competent, well, I'm not competent, the trust is irrevocable. It can be used for my dependent child. Well, now it's a resource, disqualifying them from benefits. So living trust has a special language, tying it into the special needs trust. Insurance trust for larger estates has special language in it that messes up benefits that has to be altered. Powers of attorney in case of your disability also for mom and dad have to be altered because of the special needs child. And again, beneficiary designations have to refer to the special needs trust. I'm a past president of a national organization of attorneys in 48 states, Special Needs Alliance. And my son Benji is on the current board of directors of the national organization. Every year we come out with a handbook, both in Spanish and in English, a handbook for trustees of special needs trusts. If you check number 1 on the request form, we're going to give you a PDF of the handbook. Number 6, more reading material on special needs trusts. Request number 9 and 10, we're going to give you information on taxes. One of the next questions people ask is, all right, if I have 2 kids, I divide it 2 ways, 3 kids, 3 ways, 4 kids, 4 ways. I have 7 kids, 7 ways. It's not what the law says. The law says you can do whatever you want. Spouses have certain rights, children don't. So how do we divide it up? And there's no right or wrong in this. Some people say no matter what, one child is a doctor and making a lot of money, one child special need. I'm treating everybody the same. All right, fine, there's no right or wrong. But what do people do? Some people buy an insurance policy, what they call second to die or survivorship insurance. It pays on the second passing of mom and dad to supplement the special needs trust. Equal shares, but they get the insurance trust. Some people just have different percentages. A larger percentage goes to the special needs trust. Some do a formula, which I happen to like. So example, if I know what I'm spending on my son now at age 42, I could say, okay, when a survivor, my wife and I pass away, 90 minus Mitchell's age at that time, times a certain dollar amount, which is what I'm spending now, maybe adjusted for the cost of living going forward, goes into a special needs trust. The rest goes to other beneficiaries. So again, we could do that. So we don't overfund it. Why? Well, because we don't want it collecting dust that the other kids could use the funds. So it's all possibility. Another important thing is the new law changed this year, Secure Act 2.0. It says if you leave a retirement account, IRAs, 401ks, to your typical children, they pay taxes over a 10-year period. You leave it to a special needs trust, the taxes are spread over the actuarial lifetime expectancy of the child's special needs. So there's a benefit of leaving retirement assets to a special needs trust versus leaving it to the typical children. I alluded to before, in your wills, you can nominate guardians. Even if you aren't using guardian now, you don't think you ever need a guardian, you want to be of record. Here's the Illinois statute that says that you can nominate guardians. So who's going to make choices for your child? It's the government benefits, recreation, social, employment, day programs, residential programs. Who's the best person for the job? Some people say, you know what, grandparents. Well, they're getting older. Maybe for the next 5-10 years, maybe they're the best people for the job. Is it the other children? You know, if they're, for lack of an expression, higher functioning child, do you want them to go to a sibling or not? If it's a married couple, your sister and the jerk she married, you want it to be co-guardians so that if she passed away or whatever, there's a divorce, he's still involved. So again, this is something you talk to the attorney about how to make that decision. You look at how many cards you got in your hand, you decide what the best is to make. For minor children under 18, Illinois has had short-term guardian form for years. It says we're going out of town. Child's not going with us. We could delegate our parental responsibility to somebody else, binding on schools, doctors, hospitals. But they're over 18, we'll talk about that in a moment. Before we talk about over 18, I want to talk about letters of intent. Letters of intent, I call it instructions for the future team. So basically what I'm saying is write down everything you're thinking. Family information, history of medications, not just what they're on now, but what they were on. It was a mistake, don't ever do that again. Not just what doctors they see now, the psychologists, therapists, whatever, who they saw, never do that again, because the people coming after you, trustees, guardians, may not know that or remember that. Behaviors, do's and don'ts. Buzzwords. If you say, this is my kid, you're never going to sleep. Meltdowns. What helps sometimes it'll make it worse. Thoughts about the future for employment, living arrangements. If somebody's passed away, should they go to the funeral? Should they go to the wake? Last correspondence with government benefit information. Who to talk to at the government benefit offices. Where your statement documents are being kept. Funeral desires. A lot of people will do a prepaid funeral or buy plots for their child with special needs and not tell anybody about it. Nobody knows about it. It's like a secret. And an executive summary. All this information, 30, 40 pages. You say, I'm sending it a PDF to the future team. They're mad at me. I'm telling them, you're making me feel better that I know you got it. Something, God forbid, happens. And they say, fine. I said, don't get upset, but periodically I'm going to send you a replacement. Delete the old one, you'll have it. You're giving me a peace of mind. You're doing me a favor, you have it. Then you have to do an executive summary. You had all this information. Now, God forbid, it was a tragic accident. You're saying, I gotta get through the next 30, 36, 48 hours, whatever. The Beard owns executive summary. Where's the pager number for the doctor? Where's the insurance information, the Medicaid information? Request form number 2. We'll send you a fillable PDF form you can use for that. And 3 articles that I have written on the topic. It's also on our website at rubinlaw.com. There's 3 articles that have published on this letter of intent, idea, and executive summary. It will send you along with the form. Now I'm going to talk about future team. I want to talk about siblings. Benji is current president of SIBS, which is the state chapter of the National Sibling Leadership Network. National chapters, Katie knows better than me, but probably chapters in 25 states now. If you note, on the left is Benji, free beard. On the right, you'll see Katie, a lot younger at that point. The website for this Illinois chapter is up on top, sibsnetwork.org. On the bottom, siblingleadership.org is the national organization for siblings out of state. Benji always talks about the importance of keeping siblings involved in the planning. They may have the responsibility for their loved one for more years than mom and dad did. It's important that they're part of it. They understand who's paying for what government benefits, what the government benefits are paying for, what are the rules of the road. They should be part of the planning. Want more information on SIBS and for your kids' SIB shops, number 7 on your request form. So now, I'm checking my time, okay. Child's over 18, okay. They're considered to be a fully competent legal adult until some judge says otherwise. So that means schools won't talk to you, doctors, hospitals won't talk to you, insurance claims, you got to pretend you're them on the phone. They sign documents, it's binding. You can't deal with Social Security or Medicaid. Group homes, residential, employers, they're getting married, they want to drive a car. God forbid there's a police or state's attorney issue. Questions they ask are, can this individual fully manage his or her own personal, medical, education, financial decisions? And even if they can, are they vulnerable to be taken advantage of? If so, then before you jump to guardianship, you say, what are the alternatives before we could jump to guardianship? First option, number 1, is if the individual does not have capacity to make their own medical decisions, doctor says they don't have the ability to make their own medical decisions. We have the Illinois Healthcare Surrogate Act that is in place. They have no decisional capacity. They can't make their own medical decisions as stated by the doctor. Obviously, there's no power of attorney for healthcare if they don't have the capacity to do it. Then there's a pecking order who can make medical decisions for them. Their guardian, there is no guardian, their spouse, they're not married, they don't have adult children. Then we get down to parents and siblings. So medical decisions, they can't make their own medical decisions. And there's no guardian, they're not married, no adult children of their own. Parents and then siblings are in line to make medical decisions, including end-of-life decisions. It's purely for medical. Option number 2, if they do have decision capacity, the ability to make their own decisions, then the new kid in the block is called supported decision making. Illinois, pretty new in this thing, jumped in. The Illinois statute effective February of 2022. Basically what it is a release where you can get information as the supporter for this individual. This person with special needs called the principal. It was done for individuals with intellectual or developmental disability. It wasn't done for MI, mental illness. If they have decisional capacity, make their own decisions. You get information to help them make their own decisions. You can't make decisions for them. You can only assist them make decisions, but you can stop the hand going up saying, I can't talk to you, because it's a release, basically, a general release. Statute has a proposed form inside there. If they do have decisional capacity, option number 3 is powers of attorney, which allows the principal to give you the authority as agent to make decisions for them. It doesn't cut off their rights. They still can make their own decisions, but it gives you the ability. The financial power of attorney in Illinois is a 1987 form. It's never been updated, so we have to add a lot of things in it to make it work. When mom and dad do their own powers of attorney in case of disability, They use springing powers. It only goes into effect when their doctor says they're not competent. Child with special needs, we do an immediate power, it goes into effect immediately. But we have to add things on that are not in the 87 form, because it's 36 years old. Residential matters, tax matters, employment matters, moving assets into payback trust or able accounts, privacy release, user IDs and passwords. So we have to add a lot of things into it, but powers of attorney allow you to make decisions for the person. You can make their own decisions, but it gives you the ability to make decisions subject to them overriding it. The healthcare power of attorney started in 1987, also as a one-page form, scrapped in 2011, several changes since then. Now it's like a 5-6 page form when you sign by Zoom, which now you can do in Illinois. It ends up being 7-8 pages, but it's a much better form. It says, again, I can make, if I can't make my own medical decisions, who should the doctor listen to? And there's a built-in privacy release. Even if I'm making my own decisions, you could talk to the next named agent. For those that might be listening, that have a child still in school under 22, since 2007, there's a special education power of attorney form. Mental illness, there's a 5-page mental health treatment form that is stronger than a guardianship because it allows for up to 17-day involuntary admission in a psych hospital, which you can't even do without a court order if you're a guardian. Social Security says those are great, but we have our own form. Illinois Medicaid says, okay, that's great, we have our own form. So they have capacity to sign, but they say, no, I'm not signing it. Or they don't have capacity to sign. Or they have capacity, they just can't help stop getting themselves into trouble, be it legal, criminal, personal, maybe medical health related. Or they have capacity, but they're just a danger to themselves or others. So they have capacity, but the first time you try and use the power of attorney, they don't like what you're doing, they terminate it. And it doesn't prohibit them from getting themselves into trouble. Are they vulnerable? Powers of attorney don't cut off their rights. They agreed to something, they signed something, gave away their money, whatever. It doesn't prohibit them from doing their own thing. So will it be enough? Will they be in the computer buying things with mom's credit card? So if they won't sign, or we just figured out that it's just not enough, then some form of guardianship may be necessary. Illinois statute, guardianship, you're going into court to take away rights from somebody. That's why it's the last thing we do. It's just like a school, least restrictive environment. We talk about board decision-making, powers of attorney, and only if those things are not working, it's not sufficient, we talk about the next step. Spent a lifetime trying to build up the individual's self-esteem, or give them as independent as possible to all they can be, but then we want to protect them from themselves and other people. Where do you file for guardianship in the county in which the child has a principal residence? You need a doctor's report or fairly recent law change. If it's intellectual development disability, it could be a clinical psychologist that does a report saying basically they need a guardian. Got to be served with summons to take away rights from somebody, 14 days. Doesn't have to be a sheriff serving the summons, though. They change that too. It can be a family friend or whatever. Well, I want to name one of my other children as co-guardian so they're out of state. Doesn't matter as long as they're a U.S. resident. Got to give notices to who? People that have a closer blood relationship. So if it's a divorced couple, mom's filing a petition, got to give notice to dad. Also have to give notice to any adult children, siblings. Judge can appoint somebody to make sure they really need a guardian, you're not overstepping, and you're the right people to be guardian. Depends on the county. Parents can be co. Illinois law basically says co-guardians, be it parents is co, sister and brother is co. It's up to the judge. Even divorced parents, judges can name them co-guardians. Technically, either one can act independently. However, very often third parties say, I don't want to get caught in the middle. I want both people to sign. So if agencies or third parties say we need both signatures and one person's not there, how do you get around that? Stay tuned. I'll talk about that in a minute. When can you do it? You can't do it until the child's 18. You have to go back to court if there's no money in there. The child has money, it's a few $100s just for Social Security at any time. And all the rest of their money is in trusts. You got to go back to court if you wanted the child to move into residential placement, group home, ICFDD, like Misericordia, Lamb's Farm, etc. Sterilization went in the law a number of years ago. Having tubes tied or vasectomy, you got to go back to court for that. If not, the court can require for periodic reports. Most collar counties, except for Will County, around Chicago, do it annual reports. Throughout the state, some counties say you don't have to do reports. Some say annual. For all the other collar counties around Chicago, except for Will County, basically say annual reports. But it used to be where we would have to mail it in, not go to court, but mail it in. Now it's done by e-file. More about that in a second. I talked about going back to court for residential placement. Statute says that a guardian doesn't have the authority to move a child into residential without a court order. But also says a guardian shall monitor the placement of the ward on an ongoing basis to ensure its continued appropriateness and shall pursue appropriate alternatives as needed. I tell agencies that's why you can't say to parents, you can only come on Tuesday or Saturday or Sunday at 2 o'clock. Maybe give us a week's notice or whatever. You can make some reasonable limitations, but you can't be unreasonable with the limitations because if they're guardians. I talked about the reports. State of Illinois said as a 1118, mail it in, do it electronically. It's 20, it's a new world. Cook County was exempt from that. Now finally Cook County says, okay, we'll abide by the law. You got to mail it in and do it email or online. And basically the only county, all the other counties, 102 counties, 101 say you can do it electronically. Cook County says you do it live or by mail and electronically. Guardianship is state specific. If the child moves out of state, guardians can move out of state, but the child moves out of state, got to move the guardianship. What if the child moves out of the county? Depends on the county. Example, DuPage County would make you move the guardianship. State law says if still in Illinois, you don't have to move the guardianship. So it depends on the county. So on the report, on the annual report, you put down they're now in a different county and you wait to hear from the judge. Some parents decline saying, I'm afraid they're going to hurt somebody or break something. I don't be responsible. Then what? Well, some people will talk about a limited guardianship. We'll talk about in a moment where you can protect yourself. Or you defer to the state guardian or not-for-profit that will be guardian. I was on the Guardianship and Advocacy Commission for 6-7 years. They oversee the state guardian's office, guardian of last resort, or one of the chiefs of the Arc of Illinois, Day One Pact, since the early 80s, will serve as guardians. If you're a guardian under the Health Care Services Act, you're first in line to make all medical decisions, including end-of-life decisions. Driver's license. Some of our people are going to drive a car. Illinois state law says if you go for a full guardianship, probate court is required to tell the Secretary of State that there's a plenary guardian. Why? Because the Secretary of State is supposed to invalidate any driver's license for somebody that was a plenary guardian. So this is why we tell people if the individual's going to be driving, you don't do a plenary guardianship, you got to do a limited guardianship. Problem is DMV historically, at least under the last Secretary of State, was not following the law. They say with a doctor's letter, they would allow you to drive. So insurance companies have an out. It's an invalid driver's license. The state may let you drive, but it's an invalid driver's license by statute. So therefore, if somebody's going to be driving, you do a limited guardianship. If powers of attorney, supported decision-making, but if you're going to do guardianship, do a limited guardianship, limited to just certain things. Driver's license and guardianship number 8. So limited guardianship. Somebody needs a guardian, but they won't cooperate. I don't need a guardian. I'll tell you what, we'll just do it for medical decisions and financial decisions, but everything else you can do your own. Liability concerns. If they hurt somebody, well, yeah, I'm limited guardian just for medical and financial. So they break something, I'm not responsible for their actions. They're going to be driving, again, limited guardianship. And another thing, they're doing an employment application. It says, you ever been declared to be legally incompetent? Limited guardianship is not a declaration of legal incompetence. Do I got to be trained? I've been their parent their whole lifetime. Do I got to be trained? The answer is, since September 8th, 2018, there was training required for guardians. It could be waived by good cause by the judge. Cook County was exempt until 1/1/23. Don't ask why. Now even in Cook County, there's training. Can be waived. So we go in for guardianship, we'll ask the judge to waive the parents the requirement. Sometimes yes, sometimes no. Sometimes with siblings, they don't want to do it. But it's online. You do it. You have a year to take this online course, which is no big thing. Get a certificate that you passed, and you send it in. You're done. I read a page, answer 2 questions. Read a page, answer 2 questions. Okay, fine. Co-guardians, again, law says either one can act independently, but you do have a problem. Sometimes the doctors, hospitals, agencies. So Illinois has a short-term guardian for adults, a little different, limited to 60 days in a 12-month period. You can delegate your responsibility to somebody else. So, for example, my wife and I would go out of town, fill it out, give it to my son Benji. If something, he had to get us on the cell phone, but if we need somebody's feet on the ground, he has authority for that couple of weeks, and we're out of town. So short-term guardian, that should be done when they do the guardianship. The lawyer should be giving you this form to use. We also do 2 more, one for mom to dad to mom. So if somebody insists on both people being there, you can use that form to delegate full authority. It's really baggage, you shouldn't need it, but to make people happy if they want to know that both co-guardians are agreeing, delegate full authority to the other person. Interesting enough, when I speak nationally on this, I've spoken nationally on this topic a number of times. In most states, if you're declared to be incompetent, full plenary, full guardianship, you can't vote. Not in Illinois. Declared to be incompetent, you still could vote. Look, they can't do any worse than we do, right? One information on guardianship and the alternatives, powers of attorney support decision making, is number 5 in your checklist. The request form that you've seen throughout here, you could email it to us if you want more information. We'll send you a PDF of those things. So with that, 7:38, and I'm going to open it up to Katie to do questions.